Yeah, thank you for having me. And sorry, I think the experts have said a lot, which I agree with. One thing that I want to mention that Dimas has said is that we can't give up. For example, when Uganda had their shutdown, they went to the East African court, and they did get a decision to indicate that the shutdown violated the East African community charters. So that was a plus. Of course, in ECOWAS, it's much better because you have Togo, Guinea, and Nigeria going to the ECOWAS court. I think it's the most progressive court in terms of these issues of shutdowns. And it even gives nominal penalties or damages. They may not look much, but at least it indicates that there was actually some damage done. The one interesting thing is that, so 3 or 4 years ago, I wrote a paper on the right to freedom of expression, internet shutdowns in Africa. And one of the things I said is that I do not think, and I was very confident, even the editors thought maybe I'm crazy because I said there's no way an internet shutdown of whatever form, whether partial shutdown, full shutdown, of whatever nature would happen in Kenya. But then we saw during the reject finance bill, this thing happened. And what is crazy is that nobody really took ownership apart from the statement by Safaricom CEO, which of course was not corroborated because all the tools that were used to look at what kind of shutdown was there, people said that there was no undersea cable. All the techies that I work around who test these things say, no, there's no proof that this shutdown took place. So there's something that happened in Zimbabwe where the cabinet secretary, the minister, I can't remember his minister for what, shut down the internet. And I think it's the Law Society that went to court. And one of the things that the minister was taken to task is to explain what powers did you use to shut the internet? Because within the Kenyan spectrum, there's no law that really provides for either a partial shutdown or a full shutdown. So that is one area perhaps could explore. The regulators themselves, the cabinet secretary, whoever is involved, to give proof and to explain in court how and why this happened. I think Grace has mentioned there was this document that was floating around indicating that perhaps the regulator communication authority had sent some directive to these telcos to partially to shut or to limit access to Telegram during the exam process. That really is because I think as my colleagues in the room have explained, there's definitely effect. There's definitely damage, whether economic, financial, social damage, when you carry out this shutdown, and it has been quantified. Maybe for us here in Kenya, we didn't quantify that. And when we talk about regulators, I think there's a question that was asked about the telcos, the monopoly that they wield, etc., and these big tech companies. I think one of the regulators that at times we forget to rope into this discussion is the competition authority. So when you look at, for example, in the US, the FCC takes these large tech companies to task. Of course, with Trump in office, the FCC may not have as much power, but we see antitrust authorities, especially in Europe, they take the Metas, the Alphabet to answer questions to the monopoly they wield. Because if you're able to limit socio-political rights of Kenyans through an internet shutdown, it means that you wield greater market power, and therefore should be taken to task. And the questions that should arise is that, are you actually abusing your dominant position within the market? And my answer will be yes. And if, for example, a regulator like the competition authority is not able to do this, maybe perhaps the courts will make that finding on behalf of the regulator. So that is the component that I wanted to say that perhaps may be a bit different from what the rest have said, is that we can rope in these other regulators, because I believe this is an issue that not just the communication authority, not just the data protection authority, but also questioning the dominant nature of these companies.
I think it's important, Dr. Mugambi, to highlight the fact that data laws in Kenya are still evolving, just like all over the world, because we're discovering, we're having new discoveries of data and the internet, the growth of Web3 every other day. What steps could we take moving forward to either, make sure that the laws that we put in place moving forward will work for us in an ever-evolving sector, which is the internet, if we may say?
Of course, there's no guarantee. That's why I think we're having this conversation. Because we've had the Data Protection Act since November 2019. And we are seeing that various sectors, especially in public sector, are lagging behind in terms of putting in place measures to comply with the law. So that's why it requires a multi-stakeholder approach. And I think Bomo and Dimas mentioned this. This cannot be something that you just leave to the regulators. We, the professional bodies, civil society, academia, the media also have to play a part in asking these tough questions. For example, there's the Nation Media expose that alleged that Safaricom was being used by security agents. So one tough question the regulator should ask is for maybe the security agents and the telcos to give evidence as to, or to show cause as to why action should not be taken against them. Because laws evolve, things change. There's also where we feel that some of these laws, that there are gaps. For example, ourselves at the Data Privacy and Governance Society, we are analyzing the Data Protection Act and the regulation, the 3 regulations under the Act, because our society is based off practitioners in public sector, private sector, academia, civil society, and young professionals. And in our practice of data protection compliance, we are identifying that there are gaps in the law. And we are saying that perhaps in the new year, we'll propose an amendment bill to deal with these nuanced gaps so that we can improve the practice. So it's a continuous process, and Dimas actually said, we can't give up. The strategy can't just be one. I like what Mushiri has been doing, the issues of, and Muthoni, the issue of public education. People have to be continually educated through all platforms that what do these rights, what do these access and platforms mean for us? The public interest litigation is has a part to play in this, which means the courts. The regulators have a part to play. The good thing is that the regulators, for example, the data commissioner, you can easily write a letter and ask for an investigation to be carried out, and it will be carried out, and that the offending party will be asked to show cause why action shouldn't be taken. So it's not just one approach. It has to be a multi-pronged approach. Conversation like these, conversations in the media about these issues and asking those tough questions. Of course, at the international level, of course, some of these platforms is also using the organizations that we work with to take them to task. For example, if it's a platform that is registered or housed within the European Union, having an organization take action. For example, when you look at the tea industry, it has been sued in Scotland, because people realized that it was very hard to file litigation in Kenya. So people said, no, okay, let's go to the source. Let's go to where these companies are officially registered and take action. And the Scottish courts are taking action against these large multinationals in the tea industry. So there's a lot that can be done. Just to say there's no one action. It's just a multi-pronged approach. The East African Court of Justice is an avenue. The African Court of Human Rights, the African Commission. So when we all do this, then at least we push the wheel, maybe a centimeter or a millimeter, but at least there's some progress forward. That's my view on this.
Asante Daktari, and also just for emphasizing that it is not all hope lost. But just one question before I let you go, on the aspect of something that's invoked a lot, and you've just said partial or full, it's not legal, shouldn't happen. That is the shutdown. There's that thing, national security, whether it's in the geopolitical space or whatever. It always seems like the fallback for the government in the name of national security. And you probably even heard it in the State of the Nation address, where the president even said there's a thin line between criminality and the right to protest and express one's view, where they can't separate who the criminals are and who those who are rightfully protesting. So in this particular aspect, the national security, when is there that threshold that can justify them shutting down either partial or fully in the name of national security?
There's actually an objective test, and I think Dimas can explain it better because he's litigated in this. There's a test on proportionality. One, does the law allow or provide for the limitation of rights? Second, is there another way to limit these rights? And if we are limiting, can we accept the risks and harms involved? Because also another issue is that who defines what national security is? One of the challenge we have is that when you look at the laws, like for example, the Data Protection Act, it doesn't at all define what national security is. We look at the Computer Misuse and Cyber Crimes Act. It really doesn't define what national security is. So it's, at the end of the day, you find that it's the court to carry out that proportionality test. Is the limitations clearly stated by law allowed under Article 24 of the Constitution? Secondly, is there other way to meet our objectives without limiting the rights, or for example, like shutdown? And thirdly, even if we limit the balance, what is the balance? And this has to be an objective test. So you find that the objectivity test has only been provided by the courts, and it's for that reason courts have struck down or declared certain provisions that limit, for example, the right to freedom of expression to be unconstitutional because they don't meet that threshold. And the unfortunate bit is because whoever you ask will tell you an issue is it's an issue of national security. That's why you find that even you ask contracts about technology being implemented within the public sector, and you're told, no, this is a national security issue. Well, simply, it's freedom of access to information of simple contracts, like contracts where you're digitalizing healthcare, you're digitalizing education, etc. So at the end of the day, you just have to use the courts to ensure that the questions or the checklist on proportionality are achieved. And like somebody said, let us all remember, we the people. You remember that? And I like that meme that you said. We are the ones who gave ourselves the Constitution, and we are the ones who should say when these limitations are excessive.
Asante, Daktari. She wanted to weigh in on that.
I'll just say that in our many, many years of tracking internet shutdowns, one thing that we have consistently said, and that remains true, is that there will never, ever be a justification for shutting down the internet because of the effect of internet shutdowns on people's lives, on people's businesses, on people's day-to-day well-being, right? And so there hasn't been any observation that we have made all over the world in years of tracking internet shutdowns that a shutdown has been justified. There are justifications that are normally used by governments is, of course, national security, as you've mentioned, disinformation, misinformation. But it's not proportionate. So and exams, because again, another thing that's very important for us to mention is that last year, Kenya had another internet shutdown. So let's not forget that, because they blocked Telegram during exams. And so there will never, ever be a justification for shutting down the internet as it stands right now.
Sorry, can I just add something? Yes. I wanted to add on to the whole finding a solution, and I wanted to point out something that happens in some countries and with some companies. So I think in general, it's critical for us to start making the demand for transparency and accountability a daily thing, a daily routine. So I know a lot of companies don't like to say that, like the government made requests, and they'd rather not point out to it. But there are places where, for example, the websites or applications where if there was no legal request from governments, they will post on their website and say, today we had no legal requests. On the day that they get a legal request, they'll not post anything. So you'll know that the government reached out to ask for some information. We are seeing companies like Telegram revisit their policies and say, we will share user data, including IP addresses and names, with governments if they have evidence that this user is partaking in terrorist activity, which in this country protest is about to become terrorist activities. So we don't know the involvement that private companies have with government. We don't know how much involvement government has. So how do we start to ask, was there a legal request? Meta also has this information in the transparency website where they'll point out, we received this many requests from governments. They'll point out the regions where the requests from governments are highest. Kenya is usually top of that list. So I think we should start to demand this transparency from the telcos companies here, Safaricom. How much involvement does the government have? How many requests have they gotten? So that when it comes to a shutdown, this is not a request that they feel overwhelmed by. It's something that's daily practice, and it's okay for us to demand of it.
Clearly, public participation is something we really have to do. And of course, we have to thank people like Mike Boshiru, who has been doing public participation. And you can only do that with giving civil education. Before we go to the audience, you had a question for
Yeah, interestingly, she has answered it to some extent. But to get a more conclusive response, I want to direct this question to you and probably anyone else, even you, including you as well. Because exactly, it's in view of what you said and what he said. It's not because you're in black. But yeah, she said something. I said I'd like to direct the question to you because you understand the legalities of the conversation and you understand the place of government in this whole conversation as well. At the beginning, she said, because when we mention internet shutdown, anyone would think it's a switch that's probably in Parliament 8th floor. Finya hiyo kitu. And then she said, there's no switch. It's the companies being ordered by the government to shut down the internet. And then he said, the tech companies, even the foreign ones, the ones coming to Kenya, also don't have full sovereignty